District court probably handles about 95% of all the cases that come through court. So chances are you or someone you know has been to district court. We do a wide variety of cases, people's court. I mean, we do all of the criminal traffic court, we do all of the criminal misdemeanors, and we do lower level felonies as well. And those cases, the criminal side of what district court judges do, it's a trial court. So we're hearing cases, we're making decisions, we apply the facts to the law, and we render decisions. And in the criminal context, that's more of, guilty, not guilty, probation, conditions of probation, maybe looking at underlying issues such as treatment options that might be helpful while someone is on probation, et cetera. Other things that district court judges do at the trial level, we are, if there is an appeal from a district court criminal case, that appeal actually does go to superior court. And I'll talk a little bit more in the context of the branches of government and the court system itself in just a few minutes. Guilty or not guilty or whatever the verdict is at the superior court level, if there's an appeal from what a district court judge decided without a jury in the criminal district court, people can opt in or out of a jury. Now, it used to be mandatory jury, and now they can opt in or out. But anyway, criminal only is appealable to the superior court. That's also a trial level court. All of our civil stuff and all the millions of other things that we do in district court are not appealable to the superior court. Only in the criminal context would the appeal go to the superior court before then going to our appellate level courts, which are the Court of Appeals and the Supreme Court. All of our civil cases and all of our family and all of the other issues that we do in district court, if there is an appeal, it would go to the Court of Appeals. It would go straight to the court. Superior Court doesn't really have any role in what district court judges do on the civil side. It's only on the criminal court decisions from district court that might, if they are appealed, get appealed to the superior. The North Carolina court system, there's basically the pyramid design that gives you the idea, the visual, if you will, of our court system. The base of the pyramid are shared by the district court and the superior court. We are the trial level courts that hear the cases. We hear the facts, we apply the facts to the law, we make a decision, whether it's civil or criminal. And then the intermediate appellate court is the Court of Appeals, and the Supreme Court of North Carolina is our highest court. The basic structure of our North Carolina court system is as indicated on that visual, where we've got the trial level courts at the foundation, we've got the district court where I serve, and we've got the superior court. So in general, the difference between those two, it's not really, the superior court's not really above district court. They're both on the foundational base of the trial court system. We have 15 Court of Appeals judges who sit in panels of 3. And if there's a dissent within the Court of Appeals, then it would go to the Supreme Court, our highest court, which sits as a panel of 7. So at the top of that pyramid is our highest court, which is Supreme Court. We share jurisdiction with the Superior Court on general civil cases, for example, contract disputes, personal injury cases, those sorts of things are often heard in Superior Court, but can also be heard in District Court. So we sort of share jurisdiction. In general, the jurisdictional amounts, small claims, is heard by a magistrate who is not a judge, but is under the District Court level of court. Magistrates can hear the initial small claims for 2 main areas. One is claims $10,000 or less in dispute, or summary ejectment, i.e. eviction cases. So those are all, again, part of that exclusive jurisdiction of the district court that doesn't go into Superior Court at all. Our jurisdiction on those general civil claims where the amount in dispute is more than $25,000, that's 10 is the magistrate, 10 and under, but up to 25 is sort of like the appropriate proper division for filing those sorts of claims is in the district court. That doesn't mean if you have a claim where the amount in dispute is worth 50, you can't go to district court. You can, but the other party, if they object and they want it heard in Superior Court, they can move for it to be transferred over if the claim in dispute is more than $25,000. That's like a regular contract claim or a dispute, somebody breached a contract or somebody's claiming damages for negligence in an automobile case, or that sort of thing. Monetary damages or negligence claims or intentional torts, those sorts of things that are person-to-person types of claims. Again, the Superior Court is doing the felony cases. We do lower level felony, H&I class felonies, up to 39 months as the punishment is our jurisdiction. So we can handle pleas of guilty for lower level felonies in district court. But the larger, more severe felonies are heard. That is the Superior Court's jurisdiction in the criminal side of the law. And I already mentioned on the civil side, the Superior Court's proper division for hearing of cases, but not family court cases, but general civil where 25,000 or more is in dispute. So that just gives you a good overview of the distinction between the two different trial courts. We have district court, we have Superior Court. We have 273 district court judges, of which I am one, across the state. As you know, we have 100 counties, but we're divided into judicial districts. Some counties are just their own district. I think Wake County is an example of that, District 10. We are District 6, and that includes both New Hanover and Pender. So before I take questions, let me just spend a half a minute or so on that Civics 101 that you're, I know, very familiar with. In North Carolina, I've been talking all about the judicial system, both locally and statewide, our state court system. I'm an employee of the state of North Carolina, even though I'm elected more locally in New Hanover and Pender. I do run for re-election. My term is for 4 years. The district court has a 4-year term. The other courts have an 8-year term. And I think the main reason for that is the district court, the way our current system was set up, approximately 1967, I think, where we had these districts carved out across the state and more judges at that level of court because there's a whole bunch more volume there. Like I mentioned, about 95% of all the cases that come through court are in district court where I serve. So that's why there are more of us than there are Superior Court judges. But I think they also felt like a shorter term, the original, I guess, decision for having the terms as a shorter term for we at the district court level, rather than an 8-year term as the appellate judges have, is to be more in touch with the community. And I don't know all these stats, but I think probably about a third of the states across the country have elected judicial elections just like we do. Some states have straight up appointments, which is just still political but different. And then a lot of states have started to do what North Carolina has actually talked about, but not recently, doing sort of an initial appointment through a blue ribbon commission, looking at the merit of the judges, and then having retention elections if they were doing a good job, basically just a yay or nay. So you've probably heard about that because I know you are all tuned in politically, so you're probably familiar with some states that do that. But North Carolina is straight up election. We run under a party label. I'm a registered Democrat. Some of my colleagues are Republicans, some are Democrats. You will probably already be aware that there are some contested elections in the current cycle coming up. And so, I can't really do any official endorsements, but I think it is important for y'all to understand what the races are, who the people are challenging. Some of the incumbents that are running have been challenged. The 3 branches of government are established in the federal Constitution. Likewise, our state Constitution, 1868, has 3 branches established, and that is the legislative branch. We call it the General Assembly in North Carolina, the Congress in Washington, which makes the laws. The executive branch, President in Washington, Governor here, and the cabinet, the offices of administration under the executive, which is to execute the laws, to see that the laws are faithfully executed. So that's in our Constitution, both the federal as well as the state. And then, of course, the third co-equal branch, my favorite branch, the judicial branch, is responsible for interpreting the law to decide whether a law that was passed by the Congress or the legislature is constitutional, is legal, or not. And so that's where judicial decision-making is obviously very important as part of the checks and balances that are really shown on this chart, and that's why I printed it out, because I think it does help to have a visual. But y'all know from Civics 101 the basic checks and balances that exist between the branches of government.